welcome back to another episode of All Out Nevada, your go-to podcast for insightful glimpses into the Nevada judiciary. I'm your host, Seth Easley, representing the Supreme Court of Nevada Administrative Office of the Courts. In today's episode, we are going to be covering one of the most fundamental concepts in the courtroom, evidence. What is it, what actually counts as evidence, and how does it function? We'll dive into all of that and more with my guest, Senior Judge Richard Glasson. Judge Glasson was the longest-serving judge at the Tahoe Justice Court at State Line and is now an active senior judge. Thank you very much for joining me, Judge.
Happy to be here today, Seth.
So to get started, when we say evidence in a courtroom, what really are we talking about?
Well, it depends on who's listening. A juror hearing the word evidence just can't wait to hear testimony. But when a lawyer hears evidence, it's like a scientist hearing about the periodic table. You know, when you say an element, and when you say element to somebody, they might think, oh, water, fire, wind. And when you say evidence to a lawyer, you see this thing, this monster that you had to learn. I mean, lawyers nerd out on it. Judges nerd out on it. It's so deep. It's so complex. But that's just the nerdy part. 99% of the time, evidence is just what I talked about with the juror sees. It's going to be the fun stuff. It's going to be the testimony. And most of the time, evidence just flows. But if I were to try to define it for you, I'd say evidence is an available body of facts or information indicating whether a proposition is true or a proposition is false.
Okay.
And evidence in court can be oral. It can be physical. Physical evidence could include photographs, documents, objects, recordings. It's really anything that can be perceived by the five senses.
Okay.
And I've actually had trials where people have tried, or attorneys or litigants have tried to get me to smell something or taste something. Now, of course, a judge can't smell or taste. That's not going to be on the record. But a witness can smell something and describe the smell. Like we have an officer describing the smell of marijuana, or the taste of something. And so it's anything that can be admitted under our rules that can be perceived by the senses of the trier of fact. And the trier of fact is either a judge or a jury.
Preparing for this, I reviewed some of your education that you've given during our conferences. And in it, I saw one of the ways to think about evidence is that it's information perceived by the senses, which you just said, by the fact finder. So why is that a helpful way to frame it? Well, because when you're a judge and you're dealing with attorneys, you really don't worry too much about whether the evidence is going to be relevant or not. They don't want to waste your time, and they don't want to waste their client's time because their client's being charged for it. So they're going to focus their evidence on what might be relevant. And they're going to want to be there quickly with their witnesses for testimonial evidence. And they're going to want to be prepared with the documents that they're going to want to show their client or their witness. But they want to only show relevant evidence. And it's important to remember that those five senses, the way we're going to be hearing it. The reason why I use the five senses is I represented a young man once who had been expelled from school. And as an expulsion hearing, which he was not represented by counsel, he was kept out in the hall. It was a star chamber. And while the teachers, the administrators presented all their evidence to the school board, he was kept in the hallway. And he was in the hallway with all of his exhibits and all of his witnesses. And they brought him in and said, do you have any evidence? Well, he's a high school senior who's being expelled. He's doesn't know what evidence is. Right.
And he said, I don't have any. Yet he had all of these people who had seen and heard and felt the event. And so that's when dealing with pros pers, which I do a lot as a justice court judge, when I say, do you have evidence? And they say, what do you mean? I say, well, do you want to talk? Do you want to testify? Do you want to show me a picture? Do you have a writing? Do you have another witness who might want to testify? It's anything that I can hear or smell or taste or touch or feel.
Okay.
And I use that to try to be, I guess, more avuncular or more friendly to the proper who's usually there with, you can see the whites of their eyes and they're shaking at their knees.
Right.
So you want to slow them down. And that's why it's helpful for me to think of it that way.
Okay, so on that note, how does that perspective help judges separate evidence from argument, commentary, or speculation?
Well, that's always difficult.
Okay.
Most judges that I know and most attorneys that are presenting before judges have an outline of the elements of what they're attempting to prove. And we want to fill in the blanks. For example, in the civil tort of trespass to land, if your neighbor came across and did something to you, or in the crime of trespass to land, you know what the elements of the tort or the elements of the crime are. And most judges have listed them. And if they haven't listed them, they're looking at the complaint and they've circled them. And, they're listening for, ownership, signage, warning, and then identification. And if there's attorneys in front of you and it's argument, somebody's going to point out that it's argument. Okay. And in the final analysis, you're a judge because you've been in the pit. You've seen it before. It's rare to have I don't know of a district court judge that isn't just a stellar jurist and a stellar lawyer before they became a district court judge. And our justice court judges, even the non-law trained judges, have extensive training in this. And so they go into the court with confidence that they're going to be able to separate the wheat from the chaff.
Mm-hmm. Okay. My next question is one that you've already touched on a little bit, but maybe we can expand on that. So what are some of the primary forms evidence can take in court?
Well, the most common type of evidence is testimonial. And even if it's a document, unless it's a public document that's been certified, so it could come in just with the certification, a document has to be identified by a witness. A photograph has to be identified by a witness. I would say that 99% of the evidence that's presented in court is testimonial.
Okay,
or testimonial to the extent that it's introduced in an exhibit.
Okay.
But there are also types of evidence that come in through the lawyer. If you establish basic facts, then other things can be established from that basic fact. That's why our first chapter in evidence, chapter 47, is about relevance, judicial notice, and presumptions. For example, you don't have to prove that today is February 25th. It's February 25th, isn't it? Okay, you don't have to prove that. The court can take judicial notice of that. Mm-hmm. The court can take judicial notice that we're here today in Carson City. Mm-hmm. That's a form of evidence.
Okay.
That can be introduced without any witness whatsoever. And then there are some types of evidence that come in as presumptions where if you establish a basic fact, other things flow from it. For example, in Nevada, if you put a witness on and says, I haven't heard from John Doe in 3 years, the court can presume that John Doe's dead. Now, that's a presumption that can be easily rebutted, but that's Nevada law. If you're hearing a divorce case and the husband and wife testify that child Joey was born while they were married, it's presumed that Joey's legitimate. And whoever's disputing that then has the burden of bringing in evidence to prove to the contrary. And evidence are great shortcuts for lawyers. And lawyers aren't paying the attention to presumptions that they should. They can really speed things up.
That's interesting. That's a very interesting aspect of evidence that, as a non-law trained person, I wouldn't really have thought about.
I had a civil trial in front of Judge David Gamble once, and I was, at the end of the case, my case was going down in flames. And as I was preparing, he gave us a little bit of time to prepare our closing arguments. I had my little trial book there that has all my little piece of wits and wisdom, and I went and I looked at presumptions, and there was a presumption that I had forgotten that I was able to go to my closing statement and say, Judge, it's presumed that this happened, and they haven't rebutted it. And I turned defeat into a victory just by looking at a presumption.
Like you said, underutilized this sounds like, but powerful.
It's powerful.
Yeah.
And that's why it's in the first chapter. And we don't have them here in Nevada except through common law in the Supreme Court. But California has equitable maxims in their civil code. We have the equitable maxims here through our Supreme Court, such as my favorite, the Latin phrase, expressio unius est exclusio alturius, which means that if the statute says this thing, it can never mean anything else. If the statute uses the singular, then the plural is not there. The Supreme Court throws that out there at least a dozen times every session.
Yeah.
Because the legislature, that if they wrote it that way, we're not going to interpret it otherwise.
Mm-hmm. Hi, everyone. I hope you're enjoying this episode of I'll Allow It Nevada. We're always striving to bring you valuable insights and education, not just for judicial officers, but for anyone interested in the Nevada judiciary. If you find our content helpful or intriguing, please share your experience with your friends, family, and colleagues. Your support helps us reach a broader audience and ensures that more people can benefit from our discussions. Thank you for listening and supporting I'll Allow It Nevada. Moving on from that, so how do testimony, documents, and physical objects or recordings all function in the same way as evidence, even though they come in different forms?
Well, all evidence, we use, you've seen it here at the Lex Judicia. We got the lady here for the Supreme Court that's holding the scales of justice. And that's an apt metaphor. Each side is trying to put weight on their side of the scale and take weight off the other side. And testimony can have great weight. Mm-hmm. But if a witness is shown to be unreliable, there's an instruction in Nevada, and an attorney can argue it even if it's just a bench trial, that a witness who lies about one thing can't be trusted with anything else. And so testimony is entitled to great weight, but it can be destroyed. On the other hand, a document can't be cross-examined. And so documentary evidence, especially in a contracts-type case, the document speaks for itself and has much more weight than somebody who's trying to say it doesn't read the way that you're reading it, Judge. I meant this. Well, you mean what you sign. And so a document can have a lot more weight. A photograph, I mean, you've heard the proverb, is it? A picture is worth 1,000 words.
Right.
A photograph, you can describe what happened, but you show somebody a photograph, that's pretty damning evidence. And it can be distracting too. I mean, like sometimes, you got to make sure that your evidence is relevant. Does it make an admissible fact, does it make the proposition more or less likely? If it doesn't make it more or less likely, then it's irrelevant.
Mm-hmm. An interesting consideration for evidence is whether or not it's even relevant.
That's the first thing. It's when somebody says, I'm going to call a witness, it's like, well, why is that relevant? Why do I want to hear about Mrs. Claus and what she was doing on the first night of Hanukkah?
Right. My next question was, but maybe it could be what you talked about with presumption, but are there forms of evidence that new judges tend to overlook or underestimate?
I think they tend to underestimate the power of judicial notice. They tend to underestimate the burden shifting of a presumption. If you establish a presumption, the burden of disproving the presumption passes to your opponent. And that opponent then has to get some weight on the scale to upset what the state of Nevada has said is going to be a presumed fact. Judicial notice is largely overlooked. I practice on the border, and I often have cases where I know where the state line is, but can I use that knowledge as judicial notice? Did this crime happen in California and nobody's raising it? You know, a good attorney will always go to the, quote, scene of the crime, close quote. And when you're practicing on the border, that's probably a pretty good idea. Now, a judge can't take judicial notice of where that line is, but the judge can take judicial notice that there's a line between the two states, and then there could be argument that it occurred on one side or the other. You know, there's the famous Abraham Lincoln case where the plaintiff was testifying that he could clearly identify the defendant, yet it was at night in Illinois at 2 a.m, and Abraham Lincoln introduced the almanac to show that there was no moon. Or maybe it was a moon. I can't remember. It was one or the other, but he was able to prove through judicial notice that the witness could not have seen what the witness claimed to have seen.
That's interesting. That's a part of evidence I didn't even know about.
That's okay, but there's all sorts of evidence that the judge has to look at that's not evidence. You know, what's evidence and what's information.
And that kind of leads into my next question, actually. So what are common examples of things that feel like evidence but actually aren't?
Well, hearsay,
Okay.
an out-of-court statement, is not evidence. And in a bench trial, when you don't have a jury and some witness is testifying with hearsay and there's no objections, a judge has to remember, even if there's not an objection, that hearsay doesn't have much weight. You're saying what somebody else said who's not subject to cross-examination, somebody that's not subject to the oath, and repeating. It's like the kids' game of telephone.
Right.
Oftentimes we'll hear somebody repeating what somebody said. You get the hearsay objection. Maybe there's an exception. Maybe there isn't. But then later you hear a recording of it. And the recording is vastly at odds with what the witness provided. Not just maybe off a degree or two, but sometimes reversed.
Oh, wow.
And that's why a judge, when a judge hears hearsay without an objection, you take that perhaps with a grain of salt, perhaps with a whole shaker of salt.
That's interesting. How do they kind of make that call?
It's different from each judge to each judge, each case to each case. We had an experiment in law school where a civil trial in downtown Sacramento had 3 juries. 2 of the juries were not the official jury, and only the attorneys knew which the official jury was, just to see whether or not 3 juries would come up with identical verdicts. And they didn't.
That's interesting.
I think, if I recall correctly, 2 of the juries found for the plaintiff, but the amount of damages was significantly different. And the 3rd jury found for the defense. And that allowed lawyers and law students to go on, become lawyers, to tell their clients that, look, you take this to the jury, you're rolling the dice.
Wow. It's an interesting experiment and just shows how much goes into a courtroom.
It's always a chance. There's no sure things in the law.
Right.
But other evidence that character evidence. Character evidence is introduced all the time and perhaps without an objection. But character evidence, it's opinion evidence about somebody, their propensity to tell the truth.
Okay.
To say that if he did it this way this time, he'll do it this way next time. It's very weak, and it comes in. And judges have to be aware of character evidence. Whether or not they committed a specific act or their general moral standing, it's irrelevant and unfairly prejudicial. And then the other one that we always hear about is fruit of the poisonous tree. That's excluded. If evidence comes in violation of a citizen's Miranda rights, that'll be excluded. And recently, I've seen objections to police video that they take during a traffic stop, or actually objections because the officer didn't turn on his device. An officer is now trying to testify to something that he should have recorded. You know, should we accept that when the legislature's told us that they're supposed to turn it on? Is there a reason why they didn't turn it on? I mean, I heard a case out in Lyon County, and the reason he didn't turn it on was that his battery had died. Yet he uses that camera every day. This is what the defense attorney is pointing out in argument. He's using that camera every day, and he doesn't have a spare battery, and he hasn't shot his service revolver ever in the course of duties, yet he's carrying 6 extra magazines. Why can't he carry an extra battery? And that's a good argument for maybe not giving much consideration to what the officer said with the interaction with the citizen. So that's a type of evidence. That's a type of, I would say, fruit of the poisonous tree, maybe not so poisonous, a distasteful tree.
Okay.
And the judge has to be wary of that. And that goes, again, back to presumptions.
Okay.
Because, you know, I wrote them down here, although I do have them memorized, that evidence willfully suppressed would be adverse if produced.
Okay.
You know, he could have produced that evidence, but he forgot to record it, or his battery ran down. The other one is higher evidence would be adverse because inferior was produced. If you can show that this evidence is inferior and there's better evidence out there, that we'll presume that that better evidence is adverse to the person that's, you know, giving you 2 cents instead of the whole dollar. I talked about the child and being born in wedlock and 3 years, but there's also a presumption that the law has been obeyed.
Okay.
And that's a really important presumption, especially for justice court judges when the officer's talking about the speed limit sign. And the defense will be, well, there's no evidence that the speed limit sign was erected by the Department of Transportation in accordance with the administrative code. And there's no evidence it was the proper size. And I have here all of the law about what the proper size, and the officer doesn't know the size of it. Well, we presume that the law has been obeyed.
Right.
You know, it's presumed that we are moral people. It's presumed that we're going to follow the 10 Commandments. And only how many of the commandments are now still illegal? What is it? Stealing and murdering.
Right.
Everything else, adultery, the whole Megillah, it's off the table.
That's interesting. The how many questions can be raised, but it's around the like in your traffic sign example, but that can be like, well, we're assuming that
exactly. I mean, if you go to the courthouse,
was done correctly.
You go to the courthouse and they have the sometimes they'll have the 10 Commandments out there, and you really want to kind of say, well, we're going into a Nevada court. We're going to have to cut some of these off, aren't we? Speculation evidence. Non-experts can't speculate as to what might have happened. An expert, given an appropriate foundation, certainly can speculate as to what might have happened.
With all these ideas, all these concepts, how can judges keep clear in their minds, especially new judges, what has been admitted as evidence versus what has simply been discussed?
Well, if you're a new judge and you're a new district court judge, you already know it.
Okay.
If you're a new justice court judge and your experience has been only on the criminal side or only on the civil side, or you're not law trained, you're going to be relying upon the attorneys to help you that, and you'll ask them. As I ask counsel at the close of every case, whether it's civil or criminal, first I'll say all in, all done.
Okay.
No more evidence. And then it's, all right, plaintiff's counsel, would you like to help explain to me how the evidence that was lawfully admitted at this trial applies to the elements of your claims for relief or the elements of the crime? And then they can go through it and help educate you. And then the next attorney can point out perhaps the deficiencies in the first argument and contrarian ideas. And if there's any, and they'll tell you what evidence to focus on. And as I said, if you've been a judge for more than a month here in Nevada, you've already been to the judicial college, you've already been to the baby judge school. And the most important thing a judge can say is, thank you. I want some time to go through the exhibits and I will, in a civil case, I will get my decision out within the next 48 hours. Or in a criminal case, and you don't have a jury, it's let me take a look at that, and I'll be back in a few minutes. And of course, if it's a jury case, you get to give the jury instructions and say, thanks for the good time, Mazel Tov, let me know when you're ready.
Right. A heartfelt appreciation to our guest and to everyone who has tuned into this podcast. Before we wrap up, here are a couple of quick important reminders. For continuing legal education credit, be sure to complete a certificate of attendance and email it to jepodcast@nvcourts.nv.gov. If you have any questions, topic suggestions, or comments, we welcome your input. You can email us at jepodcast@nvcourts.nv.gov or submit your topic ideas to the topic suggestion form linked in the episode description. We value and look forward to hearing from our listeners. Stay tuned for more episodes of I'll Allow It Nevada. This is Seth Easley signing off. Take care, Nevada.